Why did Dan Patterson withhold evidence in the Gypsy Rose Blanchard, Godejohn case? Nicholas Godejohn was denied his rights to a fair trial, to present a defense, to due process, and freedom from cruel and unusual punishment under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, Sections 10, 18A and 21 of the Missouri Constitution, in that the state did not disclose information and evidence in its possession to the trial counsel. Specifically, the state had in its possession and control a Canon digital camera and a 4 GB memory card. The camera and memory card were seized as part of the search of Mr. Godejohn's residence located at Cherry Street, Big Bend, Wisconsin. Due process requires the state to disclose information in its possession or control which tends to negate the guilt of a defendant as the offense charged, mitigate the degree of the offense, or reduce punishment. The state is also required to disclose evidence that would impeach state's witnesses, and to disclose any material which would show that a defendant's conviction is based on false evidence. Prosecutors are responsible for disclosure of exculpatory or impeachment evidence, regardless of any failure by police to bring such evidence to the prosecutor's attention. A prosecuting attorney violates due process if he does not disclose evidence that is favorable to the accused. 2. The prosecuting attorney has suppressed the evidence either intentionally or inadvertently, and 3. The undisclosed evidence is material. Evidence is material if it would have provided the defendant with plausible and persuasive evidence to support a theory of innocence, or would have enabled the defendant to present a plausible different theory of innocence. In this case, the Greene County Sheriff's Department in Springfield, Missouri requested that the Waukesha County, Wisconsin Sheriff's Department assist them in the investigation of a suspicious murder that occurred at 2103 West Volunteer Way, Springfield, Missouri. After the submission of an affidavit by law enforcement in Waukesha County, Wisconsin, a search warrant was issued to search the premises of Cherry Street in Big Bend, Wisconsin. Among other things, the warrant authorized the seizure of computer modem, cell phones, computers or tablets, as well as any external storage media including, but not limited to, compact discs, DVDs, flash drives, and media storage cards, or any other instrumentality capable of storing photographs or written text and photographs of Nicholas Godejohn with Claudinia Blanchard or Gypsy Blanchard. The search warrant was signed on June 15 RH 2015 and was executed that same date. June 16, the items seized pursuant to the search of Nicholas's home in Big Bend, Wisconsin were packaged and put into evidence at the Waukesha County Sheriff's Department. Detective Hancock from the Greene County Sheriff's Department, Springfield, Missouri received all the property on June 17, 2015. After June 17, 2015, the Facebook backpack and its contents were in evidence with the Greene County Sheriff's Department under the case number associated with Nicholas Godejohn. The contents of the Facebook backpack were inventoried and photographed by the Greene County Sheriff's Department. A Canon digital camera and a 4G memory card were contained in the Facebook backpack. The information contained in the digital camera and the information on the 4G memory card was never disclosed to defense counsel. Mr. Godejohn's due process rights were also violated by the state's failure to disclose the information on the camera and the information on the 4 GB memory card because it denied trial counsel access to material that could lead them to evidence and witnesses to support a defense at trial. The Missouri Rules of Discovery were put into place to allow both sides in a criminal case access to evidence and materials in order to ensure a constitutionally fair trial. Despite having the knowledge that the Facebook backpack contained a digital camera, counsel never requested to view the information contained on the digital camera, and the information on the 4 GB memory card was never disclosed by the state. Counsel had a duty to investigate and determine what information was on the camera and on the memory card since the Facebook backpack was at the scene of the crime at the time of the crime, with Gypsy and Nicholas after the crime while they were in Springfield, and was with Gypsy and Nicholas in his room in Big Bend, Wisconsin until the time of their arrest and the seizure of the backpack and its contents. The volume of discovery in the underlying criminal case is extremely large. In addition to approximately 1,549 pages of trial transcripts and multiple exhibits, the trial and appellate files include over 100 DVDs and CDs of videotaped interviews, audio-taped interviews, photographs, electronic data from social media sites including hundreds of thousands of Facebook messages alone, and over 1,300 pages of bait stamp discovery. So why didn't Dan Patterson, the prosecuting attorney responsible for bringing evidence to the trials, bring the Canon digital camera with the 4 gigabytes memory card up for evidence? And since he never did, could he have charges against him? If a state prosecuting attorney withholds evidence in a murder trial, especially exculpatory evidence, evidence favorable to the defense, several serious legal and ethical consequences may apply. The exact charges or actions depend on the nature and intent of the withholding, but here's a breakdown of potential legal charges and penalties. 1. Criminal charges. Obstruction of justice. Definition: intentionally interfering with the administration of justice. Applies when a prosecutor deliberately hides or destroys evidence. Penalty: typically a felony, punishable by fines, imprisonment, or both. Tampering with evidence. Definition: altering, destroying, or concealing evidence to impair its availability. Penalty: can be a misdemeanor or felony depending on jurisdiction and severity. Perjury: if false statements are made under oath. If the prosecutor lies about the existence or nature of the evidence during court proceedings. Misconduct in public office. Applies if the prosecutor abuses their official position in a way that violates public trust. 2. Civil liability. Section 1983 Civil Rights Violation, U.S. Code. Basis: if the accused is wrongfully convicted because exculpatory evidence was withheld. Applies under Brady v. Maryland, 1963. Requires prosecutors to disclose exculpatory evidence. Possible outcome: monetary damages for the wrongfully convicted. The state or individual prosecutor may be sued. Note: prosecutors often have qualified or absolute immunity from civil suits for actions within the scope of their duties. But if they step outside those bounds, e.g., act in an investigatory role or deliberately fabricate evidence, immunity can be challenged. 3. Professional and ethical consequences. Disbarment or suspension. Prosecutors found guilty of misconduct can be disciplined by the state bar. In extreme cases, permanent disbarment. Criminal contempt of court. If the court finds the withholding to be a willful violation of its orders or a disruption of court proceedings. So what do you think? Did prosecuting attorney Dan Patterson willfully withhold evidence that might have helped in Nick's case? Were the photographs on the Canon digital camera ones that would take away any of Nick's guilt and put all the guilt back on Gypsy Blanchard? What should happen to this prosecuting attorney if this is the case? Let me know in the comments. By the way, because of a certain content creator, I have been demonetized for a few months, and I have to do a second appeal to get remonetized at the end of April. In the meantime, if you would like to support this channel, you can become a member, or go to my Linktree and buy me a coffee. Thank you for all your support.